Ms. Schmidt, can you hear okay, ma'am?
I can. Can you hear me?
Yes, thank you.
Mr. Riggins would like to visit with me briefly in a breakout room, if that's possible.
And Ms. Schmidt, I think that Chris can arrange to get you and Mr. Riggins into a breakout room. And Ms. Schmidt, did you have opportunity to meet with Mr. Riggins in a breakout room?
Yes, we visited for about 15 minutes. And so I think we had ample opportunity to discuss a few things.
Case is entitled State of Kansas versus Wayne R. Riggins, 19 CR 502. State of Kansas appears by Assistant Butler County Attorney Cheryl Pierce. The defendant, Wayne R. Riggins, appears in person. Also appearing at this time is standby counsel Carol Schmidt. Also appearing at this time is Court Service Officer Sarah Wheeler. This matter does regularly come back before the court this date for sentencing. The court finds that all motions before the court have previously been ruled upon by opinion ruling January 20, 2023. Any subsequent motions and filings by the defendant, Mr. Riggins, are hereby overruled and denied, with the exception of the defendant's departure motion originally filed by counsel Steve Waggle and subsequently placed back before the court by the defendant, Mr. Riggins. And the court will allow each party up to 20 minutes of argument in regards to that departure motion. Before proceeding to that departure motion, the court has previously ordered that Mr. Riggins and counsel for the state, Ms. Pierce, be supplied a copy of the pre-sentence investigation report. I trust that the parties have received the same. And before proceeding any further, is there any objection to the criminal history as set forth, which does indicate a criminal history score A as in apple? Ms. Pierce?
No, Your Honor.
And Mr. Riggins?
Yes, I do object. I think the jury should be able to determine whether the criminal history score is correct.
Court overrules the motion to have the jury determine whether the criminal history score is correct or not. And subsequently, the court does adopt the criminal history as set forth, which does indicate a criminal history score A. Before proceeding to sentence, the court will listen to recommendations from counsel and Mr. Riggins as to appropriate sentence, and court will allow up to 10 minutes in regards to these recommendations. First, beginning with Ms. Pierce.
Judge, the primary offense is voluntary manslaughter. That was count 1. That has with a criminal history score of A. That is a level 3 person felony. The presumptive prison score is 233 months in DOC with 15% good time credit. There are 1,168 days of jail time credit that the defendant has earned. There would be 36 months of post-release. With regard to aggravated battery, that would be the additional offense. That was count 2, criminal history score of I. The severity level is a level 7 person felony. that would be a standard term of 12 months. The state would recommend that they run concurrent to one another. There is some cost and fees, court costs. There is a witness fee of $38.15. There's also restitution to the Crime Victims Compensation Board with regard to Mr. Carley, $8,937.55. There's also a claim with regard to Mr. Haynes. That was the victim's father. That's $879.50 for a total of $9,817.05. There is a registration component as well. I think that he has already done the notice of intent to register, and I'm not seeing that on the PSI, but there is, wait a minute, let me check. Yeah, there is a registration component, but if you'll give me a minute, I will look up the time as to what that is, because that is not connected to the PSI. If you want to proceed with further with Mr. Riggins and his recommendations, I will look that up while you're doing that, Your Honor. The state is recommending the standard term of 233 months with 15% good time credit, the jail time credit of 1,168, and the 12 months on the aggravated battery to run concurrent to one another, Your Honor.
Thank you, Ms. Pierce. And recommendations as to sentence, Mr. Riggins.
Okay, so in this case, we have a set of mitigating factors I have here. First, I just want to read what I have in my motion because it better explains everything. I have 20 minutes, correct?
For recommendations, you have 10 minutes, Mr. Carley. Excuse me, Mr. Riggins.
So this aggravated charge of voluntary manslaughter, it carries about 20 years, the 230 something month range. The sanction range set forth in Kansas sentencing guidelines for count 1, primary count, the severity level 3 personal felony with a criminal history score of A is literally a life sentence. It's a life sentence for manslaughter. A life sentence is an inappropriate sentence, Your Honor, considering the jury's verdict of the lesser degree charge of manslaughter. It's not murder. The uncontrollable conviction leads me no other option but to accept the consequences that I'm faced with. You know, as I've maintained my innocence even after this conviction, the defendant remains competent and coherent. I haven't cowered it out. I haven't claimed that I was incompetent. I've remained consistent through my defense the whole time. I've stood on what it is that I've claimed. There wasn't no need for me to make excuses for what happened. What happened. It happened out of self-defense, Your Honor. And it's just unfair sentence to give me 231 months. I mean, and here I have some mitigating factors. And the mitigating factors are, I do accept the presumed prison sentence. I know I'm going to prison. I know this is what's going to happen. I'm going to prison. I can't control it, you know. Not asking for probation. I'm not asking for corrections. I'm accepting responsibility for my actions, and I'm satisfied that I'm going to prison, you know. And I can't do nothing else about it. And so here are some more mitigating factors. The alleged victims in count 1 and 2 are the aggressors. They provoked me to use force out of fear for my life. These people provoked this situation upon me. They attacked me with a deadly weapon. The aggressor in count 1, Dana Haynes, the deceased, she conflicted bodily injury upon me, an unlawful attack by using a deadly weapon, a knife. That alone, Your Honor, should be a mitigating factor. I was attacked with a knife and a weapon. I was defending my life. And to give me 20 years for defending my life is a little excessive. You know, I don't have no ill intentions to just murder people and kill people. That's not what I do. It's not my agenda. I wasn't doing anything but gathering my belongings until I was attacked by an unstable person. That's all this ever was. And, you know, I was legally and lawfully defending myself. In fact, the situation, the mitigating circumstance that lowered the degree from murder to manslaughter is the situation of Dana Haynes attacking me with the knife. That is the heat of passion that what the state is using against me. An attack with a deadly weapon upon me. And the state is using that to convict me with the heat of passion. That's an inappropriate charge. It should be at least involuntary manslaughter, Your Honor. This doesn't even add up. If I'm committing a lawful act out of self-defense, and maybe my force was excessive, then how is this manslaughter? How is this acting out of heat of passion whenever I was acting out of self-defense? The only disputed facts at trial was the controlling aspect of this weapon. And my fingerprints and my DNA isn't on this knife. The state's witnesses clearly committed perjury on the stand. Their testimony is false. I have the reports right here. I'm not understanding why this court can't see where I'm seeing it. It's all too obvious. I've taken these reports to other lawyers. They've seen it, and they clearly can see that these witnesses committed perjury. It's clear that the state is using and soliciting perjury. And it's not fair. It's not right in the justice system. It's unfair in the justice system. Whole case, the state's whole case was set on false allegations. And this is the midst of it, Your Honor. Literally, these witnesses said they didn't see me stab anybody. And these reports, several times to these police, they told these police during the course of their investigation, they didn't see me stab anybody, and they didn't see me with no knife ever. Then they get on the stand and say that they see me stabbing this person and then putting me with a knife. That's completely different than what they told these cops. And how is it my motions are getting denied, Your Honor? It's not making any sense to me at all. And then to give me 20 years based off of false evidence, you're convicting me off of false evidence in the first place. And then to try to give me 20 years for that, for self-defense. I mean, come on, this is out of line. This is way out of line. So the facts are insufficient to meet the elements of voluntary manslaughter in the first place. There's insufficient evidence. It's out of line. They don't meet the charge of voluntary manslaughter, period. And like I said, the state's witness committed perjury several times, and it was solicited by the prosecution. Prosecution hasn't presented any evidence denying that they didn't do it. They ain't even arguing. They can't even make argument to it. They're just denying it. That's not proving that the error was harmless or that they even committed the error. This is what it does. This is what it takes to get time out of an individual to completely falsify the whole case, to convict me with false evidence, to get time out of me? Is this what the rudimentary demands of justice requires? Is this what it does? Does the KRPC and the ethics allow the prosecution to do this? How do you even have a job doing this? I don't understand it, Your Honor. The defendants, my conduct was done out of self-defense, Your Honor, hands down. I wasn't mad killing anybody. I was attacked with a weapon. I have to repeat it over and over again. I don't know how much I have to stress this, Your Honor. I was attacked with a weapon defending my life. Yes, I'm a man, but I'm trying to live this life here, and I'm trying to carry out God's purpose and fulfill my purpose in life. I'm not trying to be murdered. I'm not trying to be killed, lose an arm, a leg, have my throat slit, whatever. People attack people, and people defend themselves from people's attacks. What did I do wrong, Your Honor? To give me 20 years for defending myself, I didn't do anything wrong. I'm remorseful for the victim's death. She was like my aunt, my uncle's wife. But when that situation arose that day, I didn't have no choice but to defend myself. And the Kansas law says I don't have to retreat. Why would I retreat from somebody attacking me so they can continue to attack me? When they're already attacking me with a knife, when they've already cut me with a knife, why would I run from them? I would stand my ground and defend myself like I did. Your Honor, I filed a judgment of acquittal. Somehow it didn't get to the court. Not understanding that, I filed that.
Thank you, Mr. Riggins. Your time is up in regards to recommendations as to sentence to the court.
Less than 8 years.
The court subsequently will proceed in regards to the defendant's motion to depart from presumptive sentence, and that would once again be a 10-minute time limit, beginning with the defendant, Mr. Riggins.
Okay, well, I just ask, Your Honor, with all these mitigating factors, that I'm requesting an 8-year sentence. We are the use of deadly force was of equal force. The conduct was done out of self-defense.
I'm sorry, Mr. Riggins, I didn't get that first part of your sentence. Your face is down and the writing in your block covers up your mouth. So I need you to start over with that sentence, please. After you say you're requesting an 8-year sentence, and then go from there, please.
I'm just requesting the court grant me to depart to the I believe it is the F box or the G box. I'm just requesting that it departs, not a duration. It's just to departure over to at least a sentence of 88 months, Your Honor. That's what I'm requesting. A person with no record that has the same situation that I'm faced with can get somewhere between, I got everything all mixed up here, sorry. In the state's case, State versus Grady, 258 KAN 72, 900 P 2D 227.
Mr. Riggins,
1995.
Mr. Riggins, please speak so that we can see your face and your mouth, so the court reporter can take a good record, please.
All right, sorry, they just got the desk here is so low I can't read, and then so I'm going to try to hold it up here, Your Honor. Sorry. So, did you catch all that?
Yes.
Rhonda? All right, so that's the case law that I'm citing in this defendant in this case, it's similar to my case. It was an act done out of self-defense. They gave him corrections for whatever they did, but you know, I know I'm going to prison. It's fine, but it's in similarity to my case, and I'm just asking for the downward durational departure. I have a daughter, a 7-year-old daughter that needs me out there. The sooner I get back out there, the sooner I can support her. I mean, I've been here for 3 years. I've had time to sit and think. You know, I've sat here and I've worked my butt off learning the law, and I've worked my butt off raising all my issues and using my time wisely and using my time, you know, to learn something and to be able to use this to my advantage, not only for my sake, but to maybe benefit somebody else's sake if they have a question. I haven't been in here fighting and stabbing people and going crazy. I'm not doing that, Your Honor. My time is focused. I'm a grown man. I have children. I have a family that needs me. 20 years is a lot, and that's life sentence. And I just ask that you please find remorse, Your Honor, some way to just depart me. You know, I got 3 years in already in this county jail. That's a long time in the county jail. I've been on 23-1 lockdown, solitary confinement. I don't do nothing but study my religion, practice my religion, and study the law and read. I don't condone any nonsense within the facility or with gangs. I don't condone in that. That's not my mindset. I just want to be able to get out and be a successful person. And I believe that I'm pretty well reintegrated right now. My mind is at a level that is be exceeding anybody in this jail. I don't see nobody doing what I'm doing in this jail, fighting for my life right now. Time is outrageous that I'm looking at. You know, I just ask that you depart, Your Honor. Everything that all my arguments and the departure motions, everything's written down, case law, guidelines, the sentence is just way out of range, Your Honor. And I just ask that you depart. Please consider it. Thank you.
Thank you, Mr. Riggins. Argument in regards to the departure motion, Ms. Pierce.
Yes, Your Honor. Your Honor, as the court's already noted, Mr. Wagle did file a motion for durational departure back on June 16th of 2021. The state responded to that on September 3rd of 2021. And then Mr. Riggins filed his durational departure just yesterday, I believe, or day before yesterday. I think I got a copy of it yesterday afternoon. So I'm going to refer back to my response for the most part, because it basically does lay out the statutory authority for a departure motion. According to KSA 216815, it reads, the sentencing judge shall, it doesn't say may, it says shall impose the presumptive sentence provided by the sentencing guideline unless the court finds substantial and compelling reasons to impose a departure. If the sentencing judge does depart from the presumptive sentence, then the judge shall state on the record at the time of sentencing the substantial and compelling reasons for a departure. When we look at what compelling and substantial are, they are something that is different than status quo. The case law, State v. McKay, implies that the court's hand is forced to depart from the presumptive sentence. There's something that is unique about the case in and of itself that forces the court to depart. There's nothing in this case that would force this court's hand to depart. The defendant argues in his original motion that, like here, that this is a life sentence. Previously, he argued he's accepting responsibility. I think he's arguing that today. That the victims in this case were the aggressor. I think he's arguing that as well. Previously, he argued the defendant's age and social condition at the time of the offense, the problem with overcrowding in the penal institution, cost of taxpayers' lengthy incarceration. The defendant is sociologically disadvantaged in that he comes from a disadvantaged background and has been in and out of penal institutions since he was 13 years old. The defendant's willingness to go to prison, and he is amenable to correction. And the defendant has a young daughter who will be deprived of her father while in prison. I think that that is the argument that Mr. Wagle made. And then, of course, today, Mr. Riggins touches on all of those, but he also continues to argue that this was self-defense. And the court has already ruled on that. But what I want to discuss with the court is that the PSI in this case, and the one that was submitted back on September the 2nd of 2021, the original list 31 items of prior convictions. These are not old convictions. These are not stale convictions. These reflect an ongoing, pervasive behavior of criminal conduct by the defendant. In case 17 CR 154, the defendant was convicted of criminal damage to property, but there was a special application that was applied to the defendant, and he was incarcerated when that particular offense was committed. He was sentenced to the Department of Corrections for a term of 14 months. According to the DOC website, the defendant's sentence expired on September the 17th of 2019. That was just a few months prior to the commission of the present offense. He had just got out of prison just a few months before he committed this one. In case 19 CR 442, 19 CR 42.
I'm sorry, say that again, Cheryl. I'm sorry.
Okay. In case 19 CR 42, the defendant was convicted of domestic violence and 2 counts of assault. The defendant's probation was revoked on December 27th of 2019. The defendant's probation was revoked because he failed to complete, among other conditions, drug and alcohol evaluation and follow all the recommendations. The defendant was on a misdemeanor probation at the time of this offense as well. So when you look at Mr. Riggins' history, and the fact that while he was just released from prison prior to the fact that he committed this offense, his failure to comply with probation and his failure to comply with post-release conditions, you have to ask yourself, is there anything about Mr. Riggins that is unique, or anything about this case that is unique that would force this court's hand to depart from what is the presumptive sentence? And the answer is there is not. Mr. Riggins has been working for a long time to earn a criminal history score of A. He has engaged in what is considered violent behavior or person crimes. That's how you get to be an A on the grid, is your commission of what we consider violent person crimes. And he has done that from 2012 up until 2019, which built up his score, which created his criminal history score of A. And as I said earlier, it's not stale, it's not old, it's recent. It's within just a short period of time of his getting out of prison and prior to this case. So Judge, when you look at what requires substantial and compelling reasons for a departure, it's the state's position that the defendant has failed to provide sufficient evidence for a departure and would ask the court to deny that and ask the court to order the presumptive sentence in the PSI. And that would be the 233 months you're in DOC. Thank you.
Thank you, Ms. Pierce. And the court at this time does proceed to allocution. And Mr. Riggins, is there anything you would like to state to the court in mitigation of your sentence? And the court will allow you up to 10 minutes. Please proceed.
So in mitigation, I have a lot of mitigating factors, Your Honor. I've kind of broke it down before. Is that what we're doing here? Is I'm presenting my mitigating factors? If I'm correct.
Anything you would like for the court to consider in mitigation of your sentence?
Your Honor, yes. As I previously stated, several things. I just ask that you find it in your heart that you give me the lesser sentence. I mean, I was attacked. The mitigating factors right there in the evidence in the record. I was attacked with a knife. I was cut with this knife. The evidence is in the record. The state hasn't disproved that. And the state is arguing my criminal history score, which puts me to the A box, understood. But these mitigating factors exist. They are real. They're not false. They're not fraudulent. They are factually existing. And I believe, as any other typical person would, in defense of their life, they would defend themselves from a person's aggressor's attack, imminent attack with a deadly weapon. I was left no choice but to defend myself, Your Honor. I don't believe the life sentence is necessary. It would be unconstitutional. It'd be a life sentence for self-defense, Your Honor. Life sentence is some 4 times the sentence of what one would face with no criminal history. 61 months is what someone would be faced with for voluntary manslaughter. That's 4 times my sentence. It's 4 times that, 61 months. Even 10 years is double the sentence of what I would have if someone faced with the same charge. 61 months. This person defending their lives with no criminal history. 230 something months is what I'm faced with because of my mistakes in my past, as my mind wasn't at a matured state. So I was doing these acts, running rambunctious. I was running the streets, drug addict. I understand and I admit that I had a drug addiction problem, and I was doing these things carelessly and not caring what my criminal history was. I didn't care. But now that I've had a chance to sit and gain my mind and gain maturity and come to a state of mind that ain't living life. Doing that. That's not life. That's nonsense. I just want to be able to have a life to be able to spend with my daughter so I can use this knowledge and wisdom that I have to be able to teach my daughter things. She deserves to have a father. I'm a father. And I'm a man of God, and I believe in God, and I follow God. And I'd do anything and everything for God if my life depended on it. And that's my state of mind. I don't worship the devil. I'm not out trying to get street credibility, harming people. I'm not out doing things to gain a reputation. I don't need a reputation. In fact, I don't care what other people think about me. because it doesn't benefit me what they think. What benefits me is how I present myself and how I do things in society. And I believe that my state of mind is well matured now. And I've gotten so close with my family through this situation that it's unbelievable. And I just ask that, you depart and allow these mitigating factors to allow me the lesser sentence. These mitigating factors exist, Your Honor. I haven't seen one thing that she said that wouldn't allow me these mitigating factors. My criminal history score is set in stone. There's no doing away with that. What's done is done. But these mitigating factors are sufficient. And they exist. Your Honor, I just ask that if you have a chance to review the motion, there are several of them in here. The Kansas legislator, the KSA 214716. I ask that you depart from the presumptive sentence. And I believe I have. Let me find it here. I'm trying to find it. And let me just say, Your Honor, the prison environments, I've been there a time or two, and they're not a peaceful environment. One can utilize their time in a fashion to do as they can pave their own path and avoid violence and everything in that aspect. But the environment is just deadly. It's nasty stabbings. I've seen people's eyeballs gouged out of their head. I've seen these stabbings. I've seen people murdered in there. And they putting me in these environments. It's traumatizing to me. And this is somewhat a reintegration to me. It's not avoidable. I can avoid being involved in acts, and I don't have no intentions to go in there and do that. But I see this constantly in there, fighting and stabbing and the drug use, people overdosing and dying, and they're right in front of me, and people just sit there and watch them die. And this is supposed to help me, Your Honor. It doesn't make sense, Honor. It doesn't. And I just ask the lower sentence, the less I have to deal with that, the less I have to be around that. That would help me mentally a lot. Because seeing these things and dealing with these things, it kind of hardens you in the brain. It makes you a little hardened, and you see things a little differently, But I have morals, and I have respect for life and values for life. And I respect life so much that I chose to defend my own life. Maybe I wasn't cautious on how the person attacking me the results would have ended. But I just, Your Honor, the mitigating factor, I was defending myself hands down. Wasn't no intentional murder. Wasn't no going in and just killing this person. That's not what I do, Your Honor. Please, I ask that you depart. It was self-defense all day, Your Honor. Please, thank you.
Thank you, Mr. Riggins. And Mr. Riggins, prior to the court pronouncing judgment and sentence upon you, we've proceeded to allocution. But at this time, do you know of any reason why the court should not pronounce judgment and sentence upon you?
At this time, I believe that the only thing I have that why you shouldn't do it at this time is I still have motions for new trials and judgment of acquittals with new claims on them filed. You overruled them. I'm not understanding these claims are different than what were in my ineffective assistance counsel motion. I just ask that you would allow me to argue these motions and be able to present these to the court and then presume the sentence. Other than that, I don't know. This is my first time as a pro se lawyer, so I don't know if I need to object to the overruling on those motions, but I just ask that, the allocution, it just be delayed until I can argue these motions. I'd like to be able to present everything, Your Honor.
Thank you, Mr. Riggins.
Thank you.
Mr. Riggins, The court has taken into consideration the arguments advanced in your departure motion, and subsequently, the court does not find substantial and compelling reasons for departure. Subsequently, it is the order, judgment, and decree of this court that you're hereby sentenced to the care, custody, and control, Secretary of Corrections, State of Kansas, to serve 233 months in prison. The court does order that you be allowed 15% good time credit. Court does grant you 1,168 days of jail time credit, and the court does order 36 months of post-release supervision. The court does order you to pay the court cost herein, restitution, for a total restitution of $9,817.05. A witness fee of a $38.15. The court has taken into consideration the victim impact statements herein. As to count 2, aggravated battery, it is the order, judgment, and decree of this court that you serve 12 months in prison. The court does run count 2, aggravated battery, concurrent with count 1, voluntary manslaughter. Once again, those sentences are run concurrent to each other. There is a registration component that is involved in your sentencing, and Ms. Pierce, the court will allow input at this time in regards to registration.
Judge, that's pursuant to 224906I, and it's 15 years.
And the court does order 15 years registration herein. Any other matters to come before the court, Ms. Pierce?
Not by the state, Your Honor.
I do, Your Honor. I just have a
And
question.
Just a moment. Ms. Wheeler
No, Your Honor.
and Mr. Riggins.
Okay, so sentencing, fine, okay, but I did file these notices of appeal on the self-defense immunity motion, or should I say the ineffective assistance counsel motion on the 1507. I was just wondering if the court got that, because for some reason the court's not getting my mail from here to the jail. I filed a notice to appeal the conviction, or I mean the ruling on the 1507 motion for the ineffective assistance counsel. Is there any way I can get any type of clarification that the court got that? Because
Mr. Riggins, Mr. Riggins, the court previously has ruled, I believe that was January 20, 2023 by opinion ruling. And subsequently the court does overrule and deny any subsequent motions that you have filed subsequent to that time. As I previously have advised you, at this time, pursuant to KSA 223608C, you shall have 14 days after the judgment of the district court. This is the district court to appeal your sentence.
okay, but I was
And
I was asking right about
there being nothing.
the appeal on the 1507 motion. I submitted it to the court. I'm not getting any response from the court notifying me that
The court is advising you to appeal the decision of the court.
okay.
If
So
you so wish. If you so wish.
because I have a time limit of 30 days to be able to appeal that. So I've already appealed it, but I'm not, court ain't telling me nothing.
There being nothing further to come before the court is in recess. Good
Carol,
luck to you, Mr. Riggins.
I speak to you in a breakout room before we go, Carol. Thank you, Your Honor. Thank
I'm
you.
fine with that.
Expecting a death sentence anyway, but thank you. Prefer a death sentence next time. Carol, can I speak to you in a breakout room, please?
Yes.
Thank you, Cheryl Pierce, for doing whatever you did. You did a great job of being a great liar.
Wayne, just
I know, but you
Hold
just be over the whole time so bad. I'm gonna say something. And don't worry, the Court of Appeals won't turn their eye and head to this because they got everything filed. So have a nice day, Your Honor.